All right, good afternoon. I'm excited to welcome you to the State Bar's new series, Decoding the Law. The idea behind this series is that great legal minds have a lot to say about important issues of the day. And so how can we bring that dialogue not just to our membership, but to the community at large? And so we've launched this Decoding the series, and our idea behind this is that we're going to connect the general public with the legal community and work together to decode questions about the law. So our goal here really isn't to say, here's how you should think about the death penalty. Our goal here is to say, here's what the death penalty is about, and you can make your own decisions about how you feel about it. We kick off the series, as I said, with the death penalty, and we'll be hosting 3 separate dialogues on this over the month of March. Today, we'll begin with an overview of the death penalty. Next week, we'll have a forum on the death penalty's financial costs. And our final and third one, the week after that, our speakers will be looking at, is there a disproportionate impact of the death penalty? So we have more opportunities to help you decode the death penalty in the coming weeks. So without further ado, because we only have an hour, I'm going to introduce our fabulous panel of speakers. We have Mark Larrañaga, is a member of the Washington, Oregon, and California State Bars. Mark has practiced criminal defense for more than 20 years with a focus on capital punishment since 1999. He was the director of Washington State's first death penalty resource center from 2001 to 2006, where he provided resources, consultation, and training to capital defense attorneys throughout Washington State. And since 2006, he has been a partner at Walsh and Larrañaga in Seattle. Professor Mary Pat Truthart received her J.D. from Rutgers University School of Law and an LLM from Columbia Law School. She joined the faculty at Gonzaga in 1989, and Mary Pat teaches and writes in the areas of constitutional law, criminal law and procedure, international human rights, and mental disability law. Mary Pat has worked on filing petitions for clemency and preparing amicus briefs in capital cases, and for more than 25 years she has been involved in community education and legislative advocacy efforts involving the death penalty. To my far left is Mark Larson. He received a J.D. degree in 1985 and has served as a King County deputy prosecutor since that time. In 1993, he was named chief deputy of the criminal division, which employs over 150 lawyers. The King County Prosecutor's Office enjoys a national reputation for innovation and has pioneered specialized practices addressing sexual assault, child abuse, domestic violence, homicide response, elder abuse, neglect, and juvenile diversion. Mark is a frequent lecturer and speaker on a wide variety of criminal justice issues. Before I turn it over to the panel, a couple of housekeeping things, and I think I forgot to introduce myself. I'm Paula Littlewood, the Executive Director of the State Bar. So a couple of things. We will be reserving 10 minutes at the end of the program for questions. So if you have questions, please raise your hand and then wait for the microphone because a large portion of our audience is online today. And for webcast participants, please send your questions to the moderator through the group chat feature, and then we'll take as many questions as we have time for. So without further ado, I'm going to hand it over to our panel. Thank you.
Well, thank you, Paula, for this opportunity, and welcome to all of the live guests and those of you who might be listening online. Again, as Paula indicated, I teach at Gonzaga Law School, and so I am here to maybe provide the overview, not necessarily the academic per se perspective on things, because we are going to try to, over the course of this series, be somewhat even-handed, but I'll acknowledge I'm one of those liberal law professors that you read about in various periodicals, so I want to acknowledge that right up front. But what we wanted to talk about today is to sort of kick off this series. And again, keep in mind there are going to be 2 additional presentations, and so you'll get to hear more. But I wanted to sort of start maybe big picture, and then we'll segue into talking more about Washington State in particular, because we have 2 of the leading luminaries who are involved with criminal law practice on this panel with me. So again, thank you. So to sort of kick things off here, what are we talking about when we're talking about the death penalty? Well, I think that we want to start out and say that there is no sort of monolithic view on this, although some might argue that we're getting closer to having one in different contexts. There's definitely no perspective on this in terms of keeping the death penalty, getting rid of the death penalty worldwide. But I have to say at this point, it would be fair to say that most Western industrialized countries have eliminated the death penalty, and especially it is a condition of EU membership that countries in the European Union no longer use the death penalty. And I think some people would say that that's because of their history, especially during World War II and subsequently in dealing with issues of great concern in this regard. So when we talk about the death penalty, I think there are a lot of issues that surface. And so again, over the course of this 3-week segment, we're hopeful that we're going to be able to touch upon some of them. But I think what we hear a lot about are things such as executing the innocent. Has it happened? Does it happen? Could it happen? I think more recently, we've been hearing a lot from the courts, from the media, about botched executions, so-called botched executions, even in the lethal injection context. We want to look at some point, does this deter crime, specifically and generally? Is there discrimination in terms of the death penalty based on race, based on wealth, and such? We're also going to spend in the future almost an entire segment looking at what we call proportionality issues. So when we talk about that, we might be looking at, even in our own state, although the death penalty is applied in cases involving homicide with aggravating circumstances, we do see circumstances where people may have killed more than one victim, may be referred to as serial killers who get life without possibility of parole, and other single murderers, not to dismiss the importance or maybe the horrific nature of the crime, who are sentenced to death. We hear about the cost, and that, again, will be another piece of the future segment. And then a lot of times, certainly on the east side, where I'm from in Spokane, there's been a lot of focus on closure for family members. Can you get closure for victim family members if you don't have some system of capital punishment? And there are different opinions on that. And certainly, I hope that we have the opportunity for Mr. Larson to address the bargaining chip that the death penalty provides to the state, in some instances to get more information about crimes and so forth. Okay, so where are we right now in terms of the death penalty in the United States? Interestingly enough, there's been a huge shift in the relative recent past. So this fall, another study coming out from the Pew Research Center. And again, I think both of my MARC colleagues here will agree that the answer to the question when it's posed by a survey might vary depending on how it's worded exactly. But for the first time, only half of Americans, or slightly less than half of Americans, favor the death penalty for people convicted of murder. 42% oppose it, and others have no opinion or were equivocal about it. And this has dropped just 7 points in the last 18 months. Now, having said that, some of you are aware of the fact that we had some issues concerning the death penalty on the ballot in a couple of states, Oklahoma, Nebraska, California, in November. And there was a vote either to retain or to return to the use of the death penalty in those states. In California, interesting situation because Californians did not vote to repeal the death penalty, but they did vote to speed up the appeals process. Now, depending on how you look at that, that's a good thing or a bad thing, but there are actually people on death row in California, and perhaps Mark Larinaga can tell us more about this if it becomes relevant, who have been on death row for more than 2 decades and have yet to have their first appeal of their case. So until the recent past, all cases that were appealed in California had to go through the California Supreme Court, and obviously they have quite the backlog in looking at these things. So I think the opposition to the death penalty is the highest that it's been in the U.S. Since it was reinstated in the mid-1970s. And Mark will talk a little bit more about that in a moment. Again, not only do we have Western industrialized countries weighing in against the death penalty, the United Nations also has called for, and the United Nations Human Rights Commission passed a resolution to abolish the death penalty worldwide. You can see the United States, this was several years ago now, the United States was one of the countries that voted against abolition. And so each year, the UN has called upon state members to abolish the death penalty. And more than half of the countries in the international community have indeed abolished the death penalty completely or for certain types of crimes. 58 countries do retain the death penalty, including China and the U.S. I had the opportunity to give a lecture involving the death penalty in Shanghai, China, a couple of years ago. And it was very interesting because there was a great difference of opinion about the use of the death penalty and in what cases it might be appropriate. So the members of the audience with whom I was speaking, it was at a university, they felt as though the death penalty was most appropriate in cases involving public corruption or bribery, not for homicide cases, not that they were diminishing the life of one person, but as one of the students said to me, in a Bernie Madoff type situation, thousands and thousands of people's lives were ruined, and so we think that the ultimate punishment should be used in those types of cases, which was a bit different perspective than I had imagined. Also in China, it may be possible, although China executes more people than any other country in the world, and I think the thousands of executions that are listed on the PowerPoint slide here could be only a third of the actual executions that take place because it's a very secretive process. However, in China, under some circumstances, they have the death penalty for a variety of crimes, but it is possible for you to work your way off death row for good behavior and the likes. And so we want to keep that in mind as well. You can see the august company that we're in terms of the death penalty. So you can reach your own conclusions in that regard. But in the United States, since 1976, there have been 1,446 executions. 3 states are primarily responsible for the executions in the U.S., and those states are Florida, Texas, and Alabama, joined also by Georgia, for example. So you can see states with and without the death penalty showcased on this particular slide. And the states in purple are states such as ours, where the death penalty is still on the books. However, there has been a moratorium on executions declared by the governors in those particular states. And so these are some of the concerns that we have. Just to bring it sort of up to speed in terms of Washington State, Washington State has, since 1993, so in the past 25 years, 5 men have been executed. 2 people in 1993 and 1994 were hanged because that is still a statutory method of execution in Washington State. So you can choose hanging or lethal injection. The other 3 people who were executed by lethal injection. So why are we concerned about the death penalty now? Why are we talking about this now in Washington State? Well, I think that there's been a growing sense that we need, and I think both Marks will agree, we need to look at this perhaps from both sides because there are issues of cost, there are issues of fairness, there are issues of geographic disparities. And recently, on January 18th, 2017, you may know that current Attorney General Robert Ferguson and prior Attorney General Rob McKenna had made an appeal to the legislature to examine this topic for purposes of legislation, repealing the death penalty. And I think that there have been other efforts that we may hear about with respect to initiatives, appeals to the court to look at this, especially on proportionality grounds and so forth. I think some of the concerns from the abolitionist side of things may have to do with a couple of different areas. And the first one really is the issue of mistakes. So Do I think that any of the people who were executed in Washington State in the past 5 years were actually innocent or factually innocent, as we still we sometimes differentiate between those terms? And the answer to that is no, I do not. So in order to explain abolition in Washington State, dealing with those who have been executed, I think mistakes or death of the actually innocent is probably not the emphasis that we would have here. And I think that many people would argue it's because we have a series of checks on the process here. We have a court that's very receptive in some instances to overturning death sentences if they think, if the justices think that it's problematic. But is it possible that we could have mistakes? And the answer to that is yes. And I think that, as you can see, the Innocence Project that some people are probably familiar with has documented 157 cases of people who were exonerated, so released from death row, as a result of mistakes of various sorts. Now, how do we put this in perspective? Well, I think some people would say, great, we can see that the system is working because these people who may have been actually innocent were exonerated. And so that's a good thing from a variety of people's perspectives, and I think that that's true. What leads to execution of the innocent? And I think that you can see that there are a number of different factors here. Most notably, there are questions involving ID. There are questions involving especially people such as those folks in California who've been sitting on death row for a while. There are issues with respect to whether the evidence was collected and approached and dealt with in an appropriate way. And so that's another aspect of this. We have two cases, and I think that, of course, I would go to the most extreme examples, but I think that there are two cases in the relative recent past that it's pretty good evidence that these people were actually innocent. And so some of you may be familiar with the so-called case of the Runaway Accelerant, and that was Todd Willingham's case in Texas. Both these cases are Texas cases. And there was a really good article, in-depth series in the New Yorker magazine a couple of years ago on this particular case. Because his house burned down, and much like the new movie out, Manchester by the Sea, his children died in the fire. The accusation was that it was purposely set, and he kept explaining what had happened, and it was only after he was executed that his explanation for what transpired in terms of the so-called arson fire was basically upheld, or he got support from experts who were able to recreate the crime scene and do something similar. The second case that got a lot of publicity in the relative recent past is oftentimes referred to as the Wrong Carlos case. And Carlos was convicted of a murder. It appeared as though another Carlos may have actually been responsible for committing it, but law students at Columbia Law School, along with their professor, Jim Liebman, had done a lot of research and made this, drew this conclusion. Okay, so methods of execution since 1976. As I mentioned, lethal injection is our common method of execution, but we still do have other things on the books, including, as I mentioned, hanging. 3 states still have hanging, including our own, and there are 2 states that use the firing squad as well. So I'll just briefly mention one of the things that's happened in the recent past is a lot of publicity oriented toward the whole notion of botched executions. And so I would bring to your attention the fact that in the last couple of weeks, Justice Sotomayor brought some attention to the fact that in a case involving a fellow had requested that he be put to death by firing squad rather than by lethal injection because he thought that that would be a more humane method of execution. And she outlined in her dissent from the petition for certiorari some of the horrific happenings that had occurred with respect to lethal injection executions in our country in the relative recent past. Okay, at this point, I could, of course, say more because professors can always talk and talk and talk, but I'm going to turn this over to Mark Larinaga to bring you up to speed about some more Washington-focused issues and concerns. So thank you.
Well, thanks. Good afternoon. I've been tasked with kind of walking through Washington's death penalty statute. But before I get into kind of the nuts and bolts of RCW 1095, which is Washington's death penalty statute, I think it's necessary to put it in some historical context. And so that's what this slide is referring to. In 1972, in Furman versus Georgia, the United States Supreme Court determined that the death penalty, at least the Georgia death penalty statute, the way it was applied, was unconstitutional, and in so doing eliminated the death penalty across the country. What's important to know about Furman, as we'll see in a minute, it didn't get rid of the death penalty per se. It said that the statute, as applied, was unconstitutional, and that's a significant difference. Per se would mean, as you see on the slide, two justices, in fact, did say that it was per se unconstitutional, meaning it would be unconstitutional regardless of the statute. It's unconstitutional because of the Eighth Amendment, in large part, and about the evolving standards of decency. Their argument there was, their position there was, that we've evolved as a society to the point where the death penalty is no longer a meaningful, useful tool to punish. They did not, those, Justice Brennan and Justice Marshall did not obviously carry the day, but they were two of the majority. What did carry the day at that point is as applied, and that means that the statute and statutes that follow, which includes the Washington statute, must be applied in a way, set up in a way that eliminates the concerns of Furman. So what Justice Douglas said was that it was discriminatory, what Justice Stewart said that it was random, and what Justice White said that it was infrequent to the point of being, at least at that time, meaningless. So that put the death penalty at question at that time. States, including Washington, ran to change their statutes or at least try to bring their statutes in line with the concerns of Furman. One of the first that came out was the North Carolina, which said, okay, well, we'll eliminate arbitrariness. We'll just make it automatic. If you're convicted of murder, certain types of murder, you're automatically going to get the death penalty. The United States Supreme Court found that to be unconstitutional. And so then they have these issues about, like I said, in Zant, which means we have to narrow the focus. It's not every single murder case gets the death penalty. And we'll see how Washington attempts to do that. Only certain types of homicides are death, quote-unquote, death eligible. The other kind of competing interest, so to speak, is this Lockett versus Ohio case, and that's individualized sentencing. And you'll see, and I'll mention a phrase called mitigation evidence or mitigating evidence. And that is anything about the individual, the defendant, or the crime that the jury or if the prosecutor who's maybe deciding whether they're going to seek the death penalty to take into consideration or must take into consideration to determine what the appropriate punishment should be. So in 1977, the issue ultimately comes to the United States Supreme Court is, well, okay, is the death penalty per se unconstitutional? Is it going to be unconstitutional no matter what we do? And the bottom line is the United States Supreme Court said, no, it's not. However, it still must be constitutional as applied, going back to the issues of Furman. And the way they kind of set that up, or at least attempted to set that up, is a couple of things. Is that we need to limit the types of cases. As I said, not every murder case is death eligible. We need a murder case, and there has to be something in addition. It's called an aggravating factor. Bifurcated trials. We have a guilt or merit phase, and then we'll have a penalty phase. So they're separate. That is a factor that the court found in Gregg versus Georgia as a meaningful safeguard potentially against the Furman issues. Mitigation evidence must be permitted at the trial, and the jurors must consider it. Now, what weight they give it is up to them, but they must consider it. And at least in Georgia, in the Georgia Gregg versus Georgia, and we'll see in Washington as well, which in essence followed the Georgia statute, there's mandatory review. That if there's a death sentence, there's a process for a mandatory review subsequent to that. Now, not all state statutes have that. It's not constitutionally required, but the Supreme Court in Gregg versus Georgia, and we'll see in Washington as well, really thought that was a useful mechanism to look at or see or the issues about Furman, whether they can minimize, the statute actually minimizes those concerns. So with that being said, that's kind of the way we have to look at Washington's death penalty statute, which is, like I said, is 1095. And it was enacted in 1981. There was a couple of other provisions prior to 1981 that were deemed unconstitutional for a variety of, for other reasons. But 1981 is the current Washington's death penalty statute. And the way I kind of look at 1095, and when I'm talking about how it's applied, these are the four questions. Kind of, I don't mind oversimplifying things. And so this is the way I look at when is death eligible, who is death eligible, when is death imposed, and is the death sentence proportionate?
Mark, can I interrupt you?
Of course.
I'm having a memory, and you'll know. 1095 was brought. Was it a referendum? Was it a citizen initiative?
That I don't know.
I don't think it was the legislature. I think it was a vote of the people by some form or other, which
That may be. I don't know.
is curious, just in light of recent events about that same discussion. Okay.
So in 1984, in State versus Bartholomew, that's the first case after the 1095 was enacted or initiated, depending on whatever the way it was brought to fruition. It was the first time the Washington Supreme Court was to address the statute. Now, I got to say, in Bartholomew, it overturned the death sentence for another reason, but the issue that I want to talk about is that it's the first time that the statute was brought as being one of the challenges was that it was unconstitutional. Well, the court upheld the statute, and in part because it followed very similar, almost step by step, frankly, to the Georgia statute in Gregg versus Georgia. It limits murder to premeditated murder. It can only be imposed if there's an aggravating factor. We have bifurcation. The jury must consider mitigation. And we actually have an automatic review, a proportionality review, which I could tell you that that will be discussed in more detail in a couple of weeks. But we do have, at least in theory, the automatic proportionality review. When is death eligible? This goes back to narrowing the type of the offense. And as I said, it's not every murder case. It must be premeditated. Some states allow for felony murder, meaning I may not have intended to commit the homicide, but in the process of committing a felony, I do commit the homicide. That wouldn't necessarily, at least that very kind of crude hypothetical, wouldn't apply in Washington. There has to be a premeditated intent. But that's not enough. There needs to actually be an aggravator, a statutory aggravator. I did not list them. There are 14 of them under 1095-02L, which is a little misleading because, frankly, there's quite a few subsections to each one of those. I think one time I counted there's something along the lines of 60 different statutory aggravators. But there are aggravating factors that need to be proven. Sentencing options. There are only two in Washington state. If a person is convicted of aggravated first-degree murder, he or she is either going to get life without the possibility of parole, which it really does mean that, life without the possibility of parole. We don't have parole in this context, or the death penalty. And as Mary Pat mentioned, in Washington, the death penalty, the presumption used to be hanging. It has now changed. The presumption is lethal injection. However, kind of bizarrely, a person can choose. Who is not death eligible? I think the easier way to say that is everybody is death eligible, assuming there's an aggravated first-degree murder, except for these categorical exclusions. And that is juveniles, the person under the age of 18, and those folks who might have intellectual disability, the archaic, outdated terminology, mental retardation. What I want to kind of focus on this quickly is that, as you can see, in Washington, for juveniles, it was the court that found it to be unconstitutional. And in State versus Furman, different case than the one I mentioned earlier. What's interesting, and then under intellectual disability, it was actually by the legislature under 1095. If you look at below both of those, in Roper versus Simmons and Atkins versus Virginia, which is the United States Supreme Court that followed suit, we're about a decade later. Why I think this is interesting is that Washington has been the leading candidate in kind of what I said earlier, the evolving standards of decency. When the courts look at the evolving standards of decency, and I'm going to oversimplify this, is that they often look at when the U.S. Supreme Court is looking at it, they'll look at what are the states doing. And it's an oversimplification. They're not just simply counting the states, but that is part of the equation. And Washington, in both of the scenarios, under juveniles and intellectual disability, Washington was one of the jurisdictions that had led to the United States Supreme Court in Roper for juveniles and Atkins for intellectual disability to find that it was unconstitutional because Washington, with a few other states, had kind of led the way and said, we are not going to execute juveniles, or we're not going to be executing folks with intellectual disability. The death notice. So 1095 sets out by statute when the prosecutor, the elected prosecutor in one of the 39 counties, can decide whether he or she wants to file a death notice. And I want to make sure that it's clear. They're filing a death notice. They're not saying we're imposing the death sentence. That obviously is for a jury, but they are the ones that would file or not file a death notice, which brings in a lot of the things that we're talking about into play. And so this is the question that the statute requires the elected prosecutor to take into consideration in determining whether to file a death notice. When there is no reason to believe that there are not sufficient mitigating circumstances to merit leniency. Now, this is my personal opinion. I think that was intended to be somewhat vague, frankly, to give the elected prosecutors to have some discretion. That's the positive that I could take from that. The negative I take from that is it doesn't give a lot of guidance to the 39 different elected prosecutors. And so that could, and we'll talk about it in weeks to come, could lend itself to arbitrariness because a person may do the exact same crime in one county and not another county, or in a different county. He or she may be subject to at least the death notice being filed. If the prosecution is going to file the death notice, they have to, this is probably should go without stating it, but they need to let the defense know. Special sentencing proceeding, which is kind of a fancy word to say penalty phase. When is it held? Well, it's held when a person is convicted of aggravated first-degree murder, either by a jury or if he or she enters a plea of guilty. There's a special sentencing proceeding. This is obviously with the assumption that the death notice has been filed. Who decides? Well, unless it's waived, it's the same jury that heard the guilt phase. Now, there's some exceptions to that. For example, if some of the jurors, this would rarely happen, but if some of the jurors that heard the guilt phase could not sit on the penalty phase for whatever reason, that may change it. But most of the time, it's the same jury, except, and we'll see a little bit later, when the sentences gets reversed, because they may get reversed years later, if not decades later. And it would be very difficult, if not nearly impossible, to get the same jury that heard the case 10 years earlier to sit on. So you may have a different jury in that context. Jury selection is this will be discussed in more detail, I think, when we talk about cost. Because it is a factor that leads to why these cases cost more, these capital cases cost more. They're much more prolonged in the jury selection process. And make sure I put it in context. The jury selection process is the earlier part. It's still prior to the guilt-innocent phase. And you may ask, why is it prolonged? In a non-capital case, non-capital homicide case, in my experience, jury selection might take 5, 7 court days, give or take. Capital cases could take twice or 3 times longer than that. And for the main reason, the primary factor for that is because they do individualized voir dire, which means one juror comes in at a time. And you ask, both sides get to ask about their opinions about the death penalty. Because if a person, I was asked this earlier, if a person is absolutely opposed to the death penalty, he or she is not going to be sitting on that jury. flip side of that is if he or she says, no matter what you tell me about the defendant, the mitigating evidence, I'm always going to impose the death penalty, he or she will not would not be able to sit on this jury. So that's that for-cause challenge. That means they legally will not follow the law. And so they're going to be removed or excused, I should say, from the jury. So that's one of the reasons these jury selections really take a long, long time. Because the individualized voir dire process is really an attempt to not taint other jurors. So you don't want a juror to get up and say, well, I don't care what you tell me, or I read something about this case, and in that context, I'm always going to impose the death penalty. You don't want other jurors necessarily. The courts don't want that. So that's one of the reasons that this jury selection takes much longer in a capital case than a non-capital case. A penalty phase proceeding is very similar in structure as a guilt phase, the stuff that you might see on TV or may have participated in some other fashion. There's an opening statement. Witnesses are put on by the prosecution. The witnesses are put on by the defense. There are jury instructions. There are separate jury instructions because now we're talking about the penalty phase. So it has the flavor of a trial. The evidence that's presented is a little bit different. The evidence that's presented at the penalty phase, this is for the jury to decide whether to impose the death penalty or not, is evidence about the crime. And you may say, well, if the jury already heard about the crime, then why are we doing that? Well, that goes back to if there's a reversal and that different jury may not have heard about the evidence, some of the evidence about the crime is permitted to be introduced so that the jury can have that as a background. Victim impact evidence, and I'm not going to get too much into what that is. That's permitted. Prior criminal convictions of the defendant with some limitations, and there's disputes about all of these, and I don't want to really get into the legal challenges of it, but generally speaking, victim impact evidence and prior criminal convictions come in, and as I mentioned, the mitigating evidence comes in, anything about the defendant or the crime, and some people say, well, what does that mean? What's mitigation about the crime? Well, it could be if there's co-defendants, and I'm a lesser involved than my co-defendant buddy who's sitting next to me, that could be a mitigating factor. The question that's posed to the jury, and this is the question that is by statute. You can read it all you want, and if someone could ever explain it to me, I would really appreciate it because it is, in my opinion, convoluted. And it states, having in mind the crime of which the defendant has been found guilty, are you convinced beyond a reasonable doubt that there are not sufficient mitigating circumstances to merit leniency? I struggle with it, but that's the question that is posed to the jury. And let me make it clear. At the penalty phase, as noted by the jury instruction, the prosecution has to prove it beyond a reasonable doubt that there are not sufficient mitigating circumstances, which is somewhat of a double negative. But the burden is on the prosecution to prove that there's not mitigation. If there is a conviction, then we do have a mandatory review. And I'm not going to talk about this in any great detail because I think it's going to be addressed in subsequent presentations. But there are 4 questions that the Supreme Court must answer. Sufficiency of the evidence, whether it's excessive or disproportionate, whether the sentence was brought on by passion or prejudice. And that's one of these other parts of the statute that if anybody can explain that to me, I would love it. I'm not sure exactly what passion and prejudice is. And is there evidence of intellectual disability? These are mandatory issues that the Supreme Court has to review. And why we say it's mandatory, in part, because as you'll see in a minute, there are some individuals who waive their appeals, who wish to be executed. They're often are called volunteers. And our Supreme Court said, assuming competence, you can waive your appeals. But these mandatory review questions you cannot waive because by statute, we, the Supreme Court, must consider them. And the one that really is at play here, if you think about they're all in play, but the one the crux here is the second one, the one about disproportionate or excessive. Because really that's what that is asking is, are we still having a statute, or do we have a statute that prevents or protects against those concerns back in Furman? Because all those issues in Furman is exactly what the statute is supposed to prevent. And so that is one of the main kind of provisions of the statute for us to look back, us as a society, but us as legally as well, to look back to see whether the errors that the Supreme Court found in Furman still exist. So, look at that, segue into Furman, issue revisited 40 years later. These are the questions that I would ask that you to think about as the next two topics in the next couple of weeks, but also think to yourself about if you guys are having a discussion internally or at parties about the death penalty. The questions really go back to Furman, and I repeat that a lot because all paths go back to Furman legally. I know there's been some discussions about voting, whether we should vote the death penalty, put it to a vote. The issue to me about that is if the statute has not complied with the issues about Furman, voting really is not that important. Well, I shouldn't put it that way. It is important. It does not cure the problems. If the system is flawed, voting it in or out, whether you support the death penalty or don't support the death penalty, is really not at its core. Because if you vote for the death penalty and it's still flawed, it's a flawed system under the United States Supreme Court and case law. I'm not making a comment about whether it should be put to a vote. I'm saying if we are thinking about that, we should also be thinking about legally, does it solve the problems or has it solved the problems that's mentioned in Furman? So these are some of the questions I think that we'll be talking about in the next couple of weeks, but also I'd ask you to talk amongst yourselves and to your neighbors about, is it discriminatory? Because these are the issues that were in Furman. Is it, and we'll talk about race, geographic disparity, economics. Is it random? And you'll hear that some justices have said it's like being struck by lightning or flipping a coin. We have no idea what factors will even determine whether a person is going to get the death penalty or not. Infrequent. This is the history up to, as far as I know, up to date about Washington's death penalty. We have trial reports, and I didn't really talk about these trial reports, but these trial reports are reports that are required to be submitted to the Washington Supreme Court anytime there's a conviction of aggravated first-degree murder, regardless of whether the death penalty was sought and imposed, sought and not imposed. It doesn't matter. If there's an aggravated murder conviction, there's a trial report that goes up. And part of that reasoning, which I kind of skipped over, is that's the pool that the Supreme Court looks at to determine whether we're, at least at that level, complying with the issues of Furman. And so we've had roughly, and I may be wrong about it, but roughly 340 trial reports. And the reason I'm kind of hedging on that is some of the trial reports are juveniles. And so, as I mentioned earlier, they wouldn't be death, quote-unquote, death eligible. So, I think it's about 340, and if it's not, it's very close to that. Death notices have been filed in about 85 of those. Death sentences have been posed in 33. This is what the status of those 33. 9 are currently under the sentence of death, and they're in appeal at either the state level or in the federal level. That's an area that's very complex about how do you get from state to federal and federal back to state. But and I think when there's a discussion about costs, I think we're going to talk about the lengths of appeals and why they take so long. 18 have had their convictions or sentences reversed. It's a large number. I think I'm not very good at math, but I think it was somewhere around 70% have been reversed. For a variety of reasons, and I didn't put this down here, for a variety of reasons. Because the defense attorney didn't do his or her job, or the prosecution didn't do his or her job, or the judge didn't do his or her job, or the jurors didn't do their job. They considered things that they were not supposed to consider, or the police didn't do their job. There's a variety of reasons they've been reversed. And the reason I think that is frankly important is because it's not a simple solution or simple problem that we can throw a solution. It used to be, well, it was the defense attorneys that were ineffective, and so let's put all our resources into training them, which honestly was one of the reasons that the Death Penalty Resource Center was created. But the fact is the errors are across the board. There's been one suicide of an individual who was waiting appeal. As I mentioned, there's been 5 executions, 3 of whom were volunteers who absolutely waived their appeal. So net, we've had 5 executions in over 40 years, 2 of whom actually didn't volunteer to do it. And so we go back to these issues of Furman, and we really need to look at, because now we have, back when Bartholomew and Gregg versus Georgia, they didn't have the history. They were saying, we think this is what it'll cure the problem. Now we have 4 decades of asking ourselves, has it actually cured the problem? And those are the questions, and I think legally, that we should think about as we have these discussions about the death penalty. I don't know, Mark, did you want to come up? Or? Okay.
Yeah, so just so you know, we're not giving short shrift to our prosecutor colleague. Rather, he was graciously agreed to join us relatively late in the process, and so I think his role here will be largely to take questions with the 2 of us with respect to anything that you've heard here today. And again, I think at this point we could open this up for questions, and we're happy to respond. So it might be easiest if you addressed your questions to a particular person, but since we have the 2 marks, that could become confusing, so pointing would be appropriate as well. So we'll be happy to take questions from you at any point.
Thank you. This is a question for either Mark. As far as when I forgot the name of it, but that the document or whatever it is that needs to be filed where you're seeking the death penalty, at what stage is that done in the process, in the criminal action?
I think the statute talks about filing within 30 days of arraignment. What happens in practice, though, is that gets continued for some usually substantial length of time, during which the defense is seeking to gather materials that they want us to consider as part of the decision to file or not file. So it can go on for 3 months, 6 months. It goes on for quite a while the defense engages in what is known commonly as sort of the preparation of a mitigation report.
From online, one probably better directed to Mary. Where does North Korea stand on the most executions country list?
Well, I'm sure if we were able to get the information, it would definitely appear on the list of the top 5. But unfortunately, or fortunately, I think it would be the former, we don't have that information, actually. So perhaps my putting the 5 countries up there missed a few that we don't know about.
Thank you to all of you. A number of scholars have started to write about the influence or the distortion that the death penalty has on the rest of our criminal justice system, either in allocation of prosecutorial or judicial resources, or in somewhat whitewashing other severe penalties like LWOP. So I'm just wondering if any of you could comment in your experience on what sort of influence the maintenance of the death penalty has on other aspects of our criminal justice system.
You understand?
I'm interested to hear what you have to say, Mark.
That's a tough question. Probably the reason I'm punting is I don't have a good answer.
Here's what I would say is, the cases that typically are involved in capital litigation now, and I really can only speak to King County and nominally to Washington. I don't know what they do in Texas or Alabama, but I mean, I think these are cases that would be much talked about anyway. I mean, the truth is that these are enormous cases. If you think of the most recent ones, which was Chris Monford with the police murder, if you think about the Carnation, 3 generations and 6 different victims, I think these are cases that have tremendous, impact into our communities, almost irrespective of whether capital punishment is being pursued or not. I'm not denying that there's probably some added dimension that is a part, certainly fiscally, when we make these cases capital litigation. But I do think that just outside of that, and beyond the circle of lawyers or the judges that are handling that case, I think the communities experience these cases in a very, very deep and impactful way.
Yeah, I think I would say, oftentimes we hear from, as I mentioned, murder victims' families and what would bring them closure and so forth. And I think it's really different for different family members. I mean, for example, several years ago, there was a woman who was killed in Texas, and her killer was a juvenile. So he got life without possibility of parole. So the mother of the victim and the daughter of the victim later wanted to meet with him. They wanted to get information about what happened. And this kid who had been on drugs at the time was horribly remorseful. They worked this out through psychologists. They went through several months. But they actually had the opportunity to confront the killer, which they found to be much more healing than, an execution, for example. But that's going to differ from person to person. So how are we going to deal with that? I think the problem for political actors in the relative recent past, and this is a little bit off topic of your question, is you can't show that you're tough on crime without supporting the death penalty. And I think we've seen examples of that even in the most recent presidential campaign. Here we have a vice presidential candidate on behalf of the Democrats who has presided over executions in his home state of Virginia, even though he had worked against the death penalty at an earlier point. For example, candidate Clinton was unwilling to come out and take the death penalty off the table. So we had Bernie Sanders and Mario Cuomo in the relative recent past who have come out as vigorous opponents to the death penalty, even though all mainstream religions in the United States, most notably the Catholic Church, have recommended, repeal of the death penalty. And so I think that, from an abolition viewpoint, and also as from a practical perspective, once you have to be death qualified, you're probably going to end up in a situation where even if you don't get the death penalty, you may get what some would view as a skewed perspective on the circumstances with which people are dealing. And again, because we have some serial killers amongst us, apparently, in the Pacific Northwest, I think it's ironic that in some instances, people who have been either admitted or convicted of multiple murders have not gotten the death penalty. So I imagine that will be approached later. And so I think that the costs, the deterrent effect, and that will be discussed later, are all these things that come into criminal justice reform and the other race discriminatory, wealth discriminatory distinctions among defendants.
One of the things I want to, I'll go back to your question. One of the things I want to add to this, because I think it definitely gets lost in the shuffle, and that is the emotional and dramatic experience of jurors who are asked not only to come and sit and look at and hear about very gruesome, because they are aggravated murder cases, which they would do regardless if it was a capital case or not. But that's one part of it. The next part, however, is something that is unique, and that is we ask jurors what the punishment should be. And that process of the mitigation, for the most part, and I would say a high 90%, they are hearing very traumatic things about this individual. That doesn't excuse what he or she did, but it's very traumatic about their upbringing. And so then they hear that on top of what they've already heard about the crime. Then they are asked, should this person be put to death? And that is for those who have never had to sit, it's easy in the abstract to think about it, but those folks who have to sit and hear it and make that decision, it is incredibly emotional. And let me just kind of give you an example of that. When I've picked a jury before, we often do jury questionnaires, and they'll say, "What's your opinion about the death penalty?" And handfuls, I support it. I'm a strong supporter of it. Then they come in, and they're sitting in the courtroom, and I don't know what changed. Maybe it's that they're there, and it's now that I'm here, I support it, but I can't do it. And that, to me, is an incredible transformation, one way or the other, but a transformation and acknowledgement that these jurors are asked to do something that is incredibly difficult and traumatic. And in fact, in post-conviction, where you can go interview jurors, at least in Washington State, I've interviewed some former jurors who, and I'm not an expert, but I think had PTSD, who actually did not recall being on the jury. And there was no question that they were. And I think they were just wanting to remove themselves, intentionally or unintentionally, from the process. One final thing about that is that then we often, as I showed you, the large percent of these cases get reversed. So they have asked to sit on something that traumatic, and then ultimately, obviously not all of them, but the majority of them get reversed. And so I think we lose the perspective of the jurors in this process.
Online, are there any statistics by county in Washington for prosecutors filing death notices?
Well, I can speak to that a little bit. I think that, and I think Prosecutor Larson could talk more specifically about King County, but I think over time, maybe not in the relative recent past, but I think that there have been prosecutors who've been identified as being more inclined to serve death notices. For example, and I'll just call out this county to the south of us, Pierce County, for example. I think that now we're seeing smaller counties in Washington who are unwilling, uninterested to pursue the death penalty because of the cost, and I'm sure that's something that you'll be discussing in a couple weeks. But maybe you have a better sense of this from your prosecutors across the state, from the Prosecutors Association and so forth. Any statistics that you know about?
I don't, without being able to recite them, the answer is yes. The reports that the capital reports or the aggravated murder reports that Mark talks about, of course, documents all of these decisions, who made them when, on all of the eligible category of cases. So, and of course, yeah, certain offices do have, or prosecutors have reputations for being more or less aggressive. That's certainly true over time.
In a couple of weeks, when we get into some of the disproportionate or arbitrariness, I'll put some slides together that shows the 39 counties and what the elected prosecutors have done over the last 40 years, and you'll see that it's gone to a handful, and I don't quite frankly remember the statistics off the top of my head, other than to say, right now there is not a single death notice being filed, and most recently there was only 1 or 2 counties that sought it, where it used to be about 15. So you're seeing this trend absolutely away from prosecutors filing it, and also jurors imposing it, which kind of goes back to that evolving standards concept. What is the trend that we're moving toward? And I think in 40 years, at least prosecutors seeking it and jurors imposing it, the trend is that it's going, it's moving away from it.
I'll volunteer one comment that it's not really the subject of a question, but my boss and colleague, Dan Satterberg, when he was the head of the Washington Association of Prosecuting Attorneys, I think a year ago, he got all 39 prosecutors to agree that they should recommend to the legislature that there be a referendum to have the people decide whether we should have the death penalty in Washington or not. And it was a remarkable thing to get all 39 to agree, because they have different views of it. But I think across the board, whether they were supporters or not, there was this sense that they agreed upon. Every 30 years, people should decide whether this is really what they want.
Do you know why they decided to go the referendum initiative route rather than the legislative route? Because I think some people would argue that the initiative referendum route is definitely influenced by outside money and so forth. So why did they choose the initiative route rather than through the legislative process?
Well, how's the legislative process worked out this year?
Okay.
So there's not like there's some. I don't think that was a trick. If the suggestion is that they were doing something to avoid something else, I think they were literally calling for "let us know."
Okay, it wasn't the only option available.
No, but that was what they agreed upon.
Okay.
But it's this idea of "let us know." And curiously, as both sides of this debate, the pro-death penalty folks, I think, were feeling like, well, it's already the law. We don't want to put it on the ballot. And the folks that are abolitionists, I think, largely looked at it and said, we're not sure we'd win. So you had this odd place where you've got 39 prosecutors saying, just tell us what the law is. We've got to execute it. We have a governor right now with a moratorium. It's a very confusing environment for us to operate. We'd like to know. And right now that question has sort of gone unanswered. And so it's frustrating for prosecutors at this juncture.
Okay, I think our time is up for today, and thank you all for listening in and for coming to join us, and we hope that you will return over the course of the next 2 Thursdays to hear more about different aspects of the death penalty. And thank you so much to my co-panelists, Mark Larson and Mark Larinaga, and thank you all again, and to the Washington State Bar Association, of course.